clear that, sir, this is the miscellaneous expenses incurred by the office on your behalf. This is the bill. So it is important that you document each and every invoice against the client. Tell the client that this much of potential money could, money can be, this much of amount can be used in filing the case or litigation. So you have to be very transparent about it, right? Professional communication skills, concise and structured. You have to build a trust with the client, and whenever you give consultations, it has to be very concise and structured. Prompt responses, it gives a good trust, it builds trust to the clients if you'll be very prompt while answering or responsive to your client. Plain language is you should use a language that a layman should understand. Document oral advice. Every advice which you are giving shall be documented, because it eventually helps you to formulate and to tell your client that this much has been decided by us. For you can show and tell them everything. You can record, keep the record over the email, or it is up to you. You can keep it record at your end also. Professional tone. Maintain an objective professional tone even if the opposing counsel becomes hostile in correspondence, upholding ethical standards. Verbal and written communication. Effective communication is paramount in legal practice, yet the distinction between verbal and written forms carries significant implications for strategy, liability, and impact. Understanding these differences is crucial for every legal professional. So, verbal communications, usually whatever you verbally communicate before the court, the courtroom arguments, client consultations, negotiations, that falls under the purview of verbal communication. Pleadings, legal notices, emails, legal opinions falls under the purview of written communication. So these are the nature, tone, risk factors associated with it. Courtroom versus client communication. So communicating in the courtroom, it has to be formal and technical, objective focus, and your goal should be persuasion, and the primary aim is to convince the judge or jury through rigorous logic and compelling evidences. While communicating with the client, it has to be very simple and accessible. The client should understand whatever you're saying, what remedies you are proposing before him. He has to understand. Empathetic approach should be there. Clarity and reassurances. Legal ethics. Duty to client, fearlessly advocate for their interest, ensuring their confidence and legal rights are protected. Duty to opponent, maintain fairness and avoid malice, adhering to ethical standards even in adversarial proceedings. Duty to court, uphold the dignity and integrity of the judicial system, acting as an officer of justice. Client attorney privileged as given under BSA 2023 as well as in the Indian Evidence Act. The core principle is that clients are encouraged to be fully transparent, as all communications and shared documents remain confidential. So you cannot use those documents against your client in the court of law. It is not admissible. Statutory backing codified under section 132 of the Bharatiya Saksha Adhiniyam, replacing the Indian Evidence Act. The mandate: advocates cannot disclose clients' communication, documents, or advice without explicit client consent. Defined expectations: not applicable for communications made for illegal purpose or if a crime fraud is observed post engagement. That's very obvious. So, Advocates Act and Bar Council rules. It is very important because this provides you a framework. This provides you a statute to run your practice before the court. The professional conduct of lawyers in India is strictly governed by a robust framework, ensuring integrity, accountability, and the upholding of justice. So, the Advocates Act 1961 and the Bar Council of India rules, specifically Chapter 2 and 6, lay down the standards of professional conduct for all legal practitioners. So, duty of the court: maintain a respectful attitude towards courts, upholding judicial dignity, avoid any illegal or improper means to influence court decisions, always appear in court in the prescribed dress code and maintain a presentable appearance. As we discussed earlier, there shall be a dress code that has to be carried by an advocate before appearing the court. Duty to the client bound to accept brief in their practice area at a fee consistent with their standing. Must not withdraw from a case without sufficient cause and reasonable notice to the client. This is important, that no matter who is coming before you, have to accept the brief. Right? This is what the Advocates Act says. Of course, it's your morality also. So it is up to you. Financial and professional conduct cannot adjust fees against personal liability or lend money to clients for legal proceedings. Strictly prohibited for advertising or soliciting work directly or indirectly. So it is barred by our Advocates Act that we cannot advertise our work in on internet or in any area whatsoever. Building professional reputation. A lawyer's reputation is their greatest asset, forged through consistent integrity and professional conduct rather than mere victories. Honesty with the bench, always be truthful with judges, citing law accurately and respecting court time to build trust and credibility. See, time and again, I guess recently also Supreme Court has identified one thing that lawyers nowadays are using AI to draft their plaint, in which false and fabricated cases has been incorporated by those AI tools which are not in existence. And this has been same identified by Supreme Court twice or thrice during this span. So of course, AI is helpful, but use AI to assist your draft, but not to build it solely. And don't use AI drafts directly before the court. It is up to you. It is the duty of an advocate to scrutiny that document, to check the facts, to check whether those case laws even exist or not. Because when the court would find out such instances, it will be very disrespectful towards the court as well as towards the advocate, right? So it is the duty of the young lawyers, I would say, or the practicing advocates, to ensure that even if you are taking an assistance from AIs, don't absolutely rely on them. Of course, they can commit mistakes. It's a machine, it's a program, right? Respectful conduct, treat court staff and junior opposing counsels with professionalism and courtesy, upholding the dignity of the profession. Continuous competence, continuously update your legal knowledge. Rigorous preparation ensures competence, naturally generating client referrals and peer respect. So if you have a good knowledge and you are standing in a courtroom, it will reflect in your conduct, and you will be able to fetch more clients solely on based of your knowledge. There is a reason why it is important to stay updated in this profession, right? I guess that's all. Thank you so much for listening. Have a great day.